Hello and welcome back to the Vincent Masons podcasts. We're here trying to keep you up to date with everything you need to know from the whole world of business law news every second Tuesday. I'm Matthew McGee and I'm a journalist here at Vincent Masons. And this week we examine the unexpected implications of a ruling about tennis players' data that could hamper AI development in Europe. And we discuss how companies can cope with English judges' new power to force them out of the courts and into alternative dispute resolution. But first, here's some business law news from our Outlaw team from around the world. Australia introduces scam prevention laws. EU price comparison ruling sets 30-day rule, and Ireland's budget offers support to startups and multinational companies. Public consultation on new regulations to safeguard Australian consumers from scams has now closed, with legislation to introduce some multi-sector scam obligations supported by sector codes to be brought before Parliament by the end of this year. The Australian Government's Scams Prevention Framework, or SPF, seeks to prevent scams beginning in banking, telecommunications and digital platforms. Australian regulators say that scam activity has increased, costing consumers as much as $2.7 billion Australian dollars a year. The SPF will be administered and enforced by the Australian Competition and Consumer Commission, which will delegate its functions and powers to SPF sector regulators. E-commerce merchants across the EU may need to revisit their online pricing algorithms to ensure promotional price reductions are based on the lowest price in the past 30 days rather than the initial price of the advertised products, an expert has said. It follows a case brought by a German consumers association against Aldi over its advertised reductions and a ruling from Europe's highest court, the Court of Justice of the European Union. The CJEU ruled that price reductions must be calculated based on the lowest price applied by the trader during a period of at least 30 days prior to the price reduction. Technology expert Jeroen Schouten said an interpretation battle between the EU Commission, various national regulatory authorities and e-commerce industry stakeholders has been settled following this decision. Ireland's budget for 2025 sets out a range of tax relief measures as part of the government's aims to improve the business environment, support innovation, attract foreign investment and boost economic growth. The measures and policies to support Irish startups and multinational businesses include the increased limit on gains qualifying for angel investor relief and changes to Ireland's research and development tax credit regime. The majority of measures in the budget will take effect from the 1st of January 2025, following the passing of the Finance Bill, with some becoming effective at midnight on the 1st of October. Artificial intelligence systems need to be trained to understand how humans communicate, what good answers or solutions look like, and what questions really mean. One of the ways this is done is by feeding the systems huge amounts of data that contains actual human interaction. People often have concerns about this, some to do with the intellectual property rights of the creators of material that's fed in, and some to do with the privacy of the people whose data or interactions are used. Well, Amsterdam-based privacy and technology law expert Wouter Seinen thinks that a ruling by Europe's top court, the Court of Justice of the European Union, in a case about the Dutch Tennis Federation selling access to its members' contact details, will make it harder than ever to feed data into AI systems for training. From amateur tennis players' details to AI data guzzling is a bit of a long road, but it all started with the Dutch Data Protection Authority, the AP, telling the Tennis Federation that its use of members' data breached the General Data Protection Regulation, or GDPR.
The Court of Justice of the EU was asked to answer a almost funny question for many spectators in the data privacy scene. The Dutch Data Protection Authority has taken a quite doctrinarian view about the use of legitimate interest as a processing ground under the GDPR. If you can't get implicit consent, one of the few available options to get a justification for using personal data, for processing personal data, is actually say, well, this is actually necessary for the pursuit of my legitimate interest. So what the AP then decided at some point a couple of years ago is that actually a commercial interest, i.e. just you collect or process personal data because you want to make money with it should not be eligible for that precise processing ground. And the reasoning was, well, actually a legitimate interest should be an interest that is sort of respected and delineated by the law. And there is no law that says you have a right to make money.
This case then is all about whether having a commercial interest in using data counts as a legitimate interest under the GDPR.
The case was about a tennis federation, and at some point the federation decided that it wasn't in a very healthy financial state, and they were approached by sponsors, by companies that were interested in the membership data, just names and contact details. They could use it for direct marketing purposes, and they were willing to pay the federation, the association, some money for that. That is what took place, and for that behavior, the association was fined over €500,000. This was escalated up to the European Court of Justice, and the question was very simple: is a commercial interest, can that qualify? Is it eligible to rely upon as a processing ground of GDPR? The court essentially disagrees with the AP on the view that commercial interest could fundamentally not be eligible. So it's taken a more nuanced view. It actually says whether an interest that is being pursued is legitimate or not actually is up to the member states. It requires an assessment whether it's anything that is inappropriate or illegal, so in violation of a law. And if it's not illegal, then it could, depending circumstances, be eligible as a legitimate interest.
This is a useful and interesting ruling on a point that will interest many data processors. But the CJEU ruling didn't stop there. It went on to say, though not actually to rule as such, that a factor to consider in all this is whether the people whose data was being used knew this was happening. Because if they didn't know, they couldn't object or take action.
But then the court continues by saying, well, whether a legitimate interest can be relied on in the circumstances of an individual case really depends on the expectations of the users involved. The court here reasons if a user doesn't know, then it is unable to exercise its rights or to make objections or whatever. So it is important that once an organization relies on that ground, they should be sufficiently comfortable that the data subjects indeed knew or could have known.
This is the part of the ruling that Wouter thinks could affect AI training. First, he told me how data is used to train AI systems, then how those CJEU comments might apply.
This decision could inform the future thinking on when is an organization actually allowed, when is it permissible under the GDPR to share volumes of data that include personal data.
It remains to be seen how enthusiastic judges will be about actually compelling a reluctant opponent
even
to
if the
engage
use
in a
case is quite
form
innocent
of ADR.
And there's no real harm to the
partly
users,
because the greater the degree of
it
willing
could
buy-in
become more
from
problematic now to say, well,
process,
we did this for the good cause, we think it's a normal thing.
But nonetheless, there will be that stronger backing in the rules there and potentially stronger
encouragement. A data protection authority could go back to this decision and say, well, if the tennis association could have informed first, why could you as a commercial business not just go back to everyone involved and notify them of your plans before you would do that, before you would really start sharing the data for instance, training of AI. Many AI systems really at this moment are trying to understand how people communicate and how people reason. So for that, it is needed for the systems to get access to large volumes of data, and that could be internal correspondence, that could be business files, that could be all kinds of communications, but most interestedly if it's a dialogue, if it's you and I that are exchanging views to